Good afternoon, everyone. My name is Sarah. On behalf of all of us, we want to wish you a very happy Charter Day. Today marks the 38th anniversary of the adoption of the Canadian Charter of Rights and Freedoms. So welcome to our special Charter Day webinar celebrating Canada's fundamental and sometimes forgotten freedoms. Our panel of legal experts has a lot to pack into today's webinar, so I will just briefly go over some housekeeping items with you. As this is a webinar format, you are muted and we cannot see your video, so relax and enjoy the webinar. There will be a time for questions and answers at the end of the presentation. We encourage you to go ahead and use the Q&A box, which you'll find on the bottom or top banner of your Zoom platform throughout the webinar. You can submit questions to the panelists, and you'll also note that you can do so anonymously. There will also be polls circulating during the webinar. You do not have to answer them, but they are engaging and thoughtful questions, and your feedback is appreciated. If you're having any technical difficulties throughout this webinar, please use the Q&A box and we'll do our best to help you. You can also send us an email to office@christianlegalfellowship.org. I would now like to briefly introduce you to our panel of experts, which includes Brian Byrd of Princeton University, Professor Jamie Cameron of Osgoode Hall Faculty of Law, Professor Dwight Newman of the University of Saskatchewan Faculty of Law, and Derek Ross of Christian Legal Fellowship. Today's panelists are experts in these areas of law and more, and are very well accomplished. And though today's webinar doesn't allow me the time to read their full bios in a way that they deserve, we encourage you to head to christianlegalfellowship.org/charterday for more background information. And in case you missed it, we also launched a new video today to commemorate Charter Day, and you can find that as well on the website, christianlegalfellowship.org/charterday. So without further ado, I'm going to turn things over now to one of our panelists, Derek Ross.
Wonderful. Thank you so much, Sarah, and welcome everyone. Great to be with so many of you across Canada this afternoon, depending on where you're located, to be talking about the Charter and specifically Section 2 of the Charter. And I just want to open with some general remarks on what Section 2 protects. As Sarah mentioned, today is Charter Day. It's the 38th birthday of the Charter, which means that on this day, April 17th, 38 years ago, the Charter was adopted into our Constitution. What that means is that it is now, and has been for the last 38 years, part of the supreme law of Canada. Now, the Charter isn't the only part of the Constitution. It's part of it, and it's an important part of it, but the Constitution has quite a number of other documents and provisions and protections as well. But the Charter is certainly the one that garners most attention, I think, in our public discourse and in the media, and that is in part because of its importance and its impact on our day-to-day life. It really is something that protects exercises that we engage in our day-to-day activities. And that is particularly true of Section 2. So Section 2 of the Charter is what sets out our fundamental freedoms, our guarantees of the freedoms that we enjoy in Canada. And the slide that we're sharing shows you the exact text from the Charter. Some of you have this memorized. Some of you, this might be the first time you might have looked at this closely. And so there's 4 paragraphs in Section 2 in terms of the freedoms it protects. Freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication, freedom of peaceful assembly, and freedom of association. Now, we're talking today, though, about this idea of forgotten freedoms, and that's because although these are all set out in the Charter, these are all guaranteed, these are all part of our constitutional rights, really the majority of them have not yet been independently considered or interpreted or applied by our courts. In fact, really, the only ones that have been given significant and thorough examination are freedom of religion in Section 2A, freedom of expression in Section 2B, and to some extent, freedom of association, although, as we'll talk about, the discussion and the judicial discourse surrounding freedom of association has really been limited to the labor context, to the right to collective bargaining and to have unions, and has really not been considered outside of that realm. So really we've got, you know, 2.5 of all of these freedoms that have been considered in our first 38 years. And so as we're looking to the next 38 years and beyond, we're wanting to give some consideration to what each of these freedoms might protect. Now, we're going to get into a little bit more about what freedom means, why it's so important, why do we designate these freedoms as fundamental. Before we do, we're going to invite you to participate in a poll. And we're going to ask you which of these freedoms are most important to you. So I'm going to launch the poll now, and hopefully you will now be seeing a poll that's popped up on your screen that will ask you which of these freedoms do you think is most important. And we'll look forward to getting your responses on that. The other thing that I'll say as well is that we're focusing on the Charter today. It's important to remember that 1982 wasn't the first time that freedom was enjoyed in Canada, that all of these freedoms to varying extents were recognized and have been recognized earlier and throughout our history. We had a Bill of Rights before the Charter, although that was not a constitutional document, which meant it wasn't part of the supreme law. And we also have common law and pre-charter jurisprudence where judges have recognized an implicit and inherent and natural freedom of expression, freedom of religion. But really it wasn't until the Charter in 1982 that those were firmly and explicitly entrenched in our Constitution. And what that means, by the way, when we talk about the supreme law, what that means is all other laws in Canada, all government actions, any decision made by an administrative body, all have to conform to this document. This is supreme. It trumps everything else. It is the ultimate law. However, these freedoms are not absolute. And that's the last thing I'll mention as you finish up on the poll. That Section 1 of the Charter indicates that these are not absolute protections, that the government may sometimes be justified in placing a limit on some of these freedoms, but that limitation has to be demonstrably justified in a free and democratic society. And there's been a separate test. Many of you are familiar with the Oakes test in the context of legislation, or the Doré test in the context of administrative action, where the government has to show why any limitation on these freedoms is justified. And what, I think we're experiencing right now with COVID-19 is exactly that. We're seeing unprecedented, even radical limitations on our freedoms, where laws are being passed restricting our ability to gather, to gather together, to move, to basically leave our homes in some contexts. And that is a huge intrusion of our fundamental freedom. Of course, the government would say, and I think most would agree, that these are largely justified in order to protect health and the safety of others. But it's important that the government is always showing why these limitations are justified. And in some cases, even with some of these particular measures that are currently being passed, there is legitimate debate as to whether they are in fact demonstrably justified. And we can maybe talk about that a little bit later on. So I think most of you have voted. I'm going to end the poll and let's see where folks have landed. So it looks like 2A and 2B are the front runners in this poll. Most of you prioritize freedom of conscience and religion, about 50%. 44% have emphasized Section 2B, and then 3% each for 2C and 2D. And that might be in part because 2C and 2D have not yet really been fully examined, and we'll talk about that later. So with that, I'm going to turn it over to Professor Cameron. And Professor Cameron, we've asked you to just share some reflections on what is meant by freedom, and why is freedom fundamental in a democracy like Canada's? So over to you, Professor Cameron.
All right, thank you very much, Derek, and good morning and afternoon, webinarists from across Canada. I'd like to begin just by thanking the organizers, the Christian Legal Fellowship, Forgotten Freedoms Project, and Derek Ross for including me in the webinar this morning. And I hope those that are joining in enjoy the session. So I have been given the welcome but quite intimidating task of thinking out loud about freedom for only a few minutes. So one thing I'd like to say, and it's already been said by Derek, is that of course this is timely and poignant. It is, of course, the Charter's birthday, but we are also going through a period of unprecedented fear and worry about the pandemic. but also about the threat it poses to our freedoms. So without saying more about specifics, what I'd just like to reinforce is that this should be very much a matter of public discourse, something that we talk about and process as a democratic community. It's not a matter of abstract principle. And so in thinking about freedom and what makes it fundamental, I'm going to keep this really, really simple. And I'll begin by saying, I think that we do understand freedom, but I'm not quite as sure that we understand exactly what it means and what it requires of us. So I'm going to just say a couple of things about that. And perhaps the best way I can put it is this. Freedom means nothing really, does it, if my freedom is protected and yours isn't. And the reason I think freedom is hard, not easy, is because it requires all of us to show respect for difference. So just as it requires you to respect my differences, it requires me to respect yours. And I would say furthermore that freedom really means nothing if we silence the voices and ideas and practices that we don't like, or if we silence ideas and practices and views because we think we're right. Freedom means that we do have to take risks, and we have to allow our beliefs and values to be challenged. And so it's my view that what freedom really asks us and asks our community to do is to be generous and humble and courageous in the face of what is never truly, all of what we can never truly know. And just on the point about freedom requiring courage, I'd just like to make a very quick reference to public libraries and controversies that has taken place in public libraries in Toronto and Vancouver in recent times, where the libraries went ahead, and I would say courageously, to give space to controversial speakers in the face of very, very significant opposition, pushback, and controversy. Anyway, what I'd like to do is just go on and say that freedom also requires us to recognize that allowing space for others and for difference is very much in our self-interest as individuals and as a community, because our progress and our capacity to grow depends on our social and democratic functions and practices and values being open, and more particularly being vulnerable to change. And I think being vulnerable to change is an important part of it for me. I guess I take the view that we have more to win than lose by respecting the differences between us and listening to them and giving them democratic space. So I didn't watch my time on that, but I think that's pretty much all I would like to say as kind of an opening reflection on freedom and why I think it is so fundamental to our democratic society. So I'll leave it at that, Derek, I think, and look forward to hearing what Dwight has to say.
Thanks so much, Jamie. That's terrific, and really agree with your comments about freedom requiring courage, and I think that's a very apt observation. Dwight or Brian, do you have any further reflections on that question as to why freedom is important, why it's fundamental?
So Dwight unmuted himself, so I'll let him take the first try.
Oh, well, thanks for handing off the challenging question. But I think it's also part, and I agree entirely with the comments from Professor Cameron, but I just emphasize the importance of freedom in terms of what it means to be human and being able to have autonomy within an ordered society, but having that is really part of what it means to be human, and it's very important then that we have those constitutional protections. And so that's just one thought that I would emphasize and add, I think. But Brian, I'd be interested in your thoughts as well.
Sure. I should say I agree with with what Professor Cameron said and what you just said, Dwight. But I think another part of the equation, this comes up in actually the first Supreme Court decision to ever deal with one of the fundamental freedoms, Big M Drug Mart, it's called, which is a fascinating decision, is the kind of the linkage between freedom and the ability to be a democracy, to kind of make informed choices, to try to structure the society we think is, good and just and equitable and is, good in a kind of a normative sense. So without these freedoms to associate, to peacefully assemble, to express ourselves, to think freely, to exercise our conscientious convictions, our religious convictions, not only is there an individual kind of benefit, but there's also this societal kind of collective democratic benefit to try to build the free and democratic society that Canada is set out to be. Derek put forward the standard for limitation of any freedom or right in the Charter, and that phrase, free and democratic society, of course, freedom is built into it right there. But without these freedoms, we're not going to be able to, I think, effectively or meaningfully kind of reach that promise or that goal for Canada that's set out in the Charter itself.
Yeah, thanks, Brian, and echo those remarks as well. I think really what freedom ensures is that there is no oppression of citizens in a democracy, that the government does not have a monopoly on power, that there's still an equalization of power imbalances to ensure that no one can coerce or suppress or silence eyes and proclamation of truth. And so I'm reminded of the closing paragraph of the British Columbia Court of Appeal in the Trinity Western case. And whatever one thinks of that decision and that outcome, I think this closing paragraph really captures very well why freedom is so important. A society that does not admit of and accommodate differences cannot be a free and democratic society, one in which its citizens are free to think, to disagree, to debate, and to challenge the accepted view without fear of reprisal. A well-intentioned majority acting in the name of tolerance and liberalism can, if unchecked, impose its views on the minority in a manner that is in itself intolerant and illiberal. And I think freedom and the freedoms that we look to in Section 2 are designed to protect us from an intolerant and illiberal society. So Dwight, we're going to shift gears a little bit and talk about this idea of forgotten freedoms and what it is to be forgotten and why it is that it's being suggested that some of these freedoms have been forgotten. You've really been a leader in this area of scholarship with your work on freedom of thought that was published last year, and of course in the forthcoming volume, and want to invite you to share some of your reflections on what it is to be forgotten freedom.
Sure, and so I just say at the outset, thanks to Derek and to the Christian Legal Fellowship for organizing today's event. There's a co-sponsorship with also this group called the Forgotten Freedoms Project, which is really meant to be an academic project that wrestles with these various forgotten freedoms, some of which are within Section 2 of the Charter. And that's our present focus in this partnership with Christian Legal Fellowship. And there's a very significant degree to which a number of the Section 2 freedoms are forgotten, in the sense that although there's a constitutional protection there, there's very little constitutional jurisprudence on that. There's very little guidance on what that freedom means in Canadian law, and ultimately, thus very little simple chance to use that freedom in the courts. And that's one of the real difficulties with these freedoms becoming forgotten, as it were. So Derek's highlighted really well with the aid of that slide, just all of the text of Section 2 that hasn't received attention. And these parts weren't there frivolously. They were discussed at length in the discussions leading up to the adoption of the Universal Declaration of Human Rights, which has very similar freedoms within it that then ultimately got carried through into the Canadian Charter. And these various freedoms are all very important, but for a variety of reasons they've come to be forgotten. Those that are within Section 2 other than religion, expression, and to some degree association, most of them there's very little jurisprudence. So part of that might be because of the history, that in 1982 these weren't freedoms that were being especially threatened by Canadian law. And they weren't as endangered as religion, expression, and to some degree association by various kinds of legal regulation. And so they didn't receive a lot of attention initially. There's what we might call, I don't want to put overly technical terms on things, but what we might call a path dependence that goes on then. Once some freedoms have received interpretation and others haven't, if there's an issue that arises that somebody might litigate under one of the freedoms that has received protection or under one that hasn't, or received interpretation or one that hasn't, there will be a natural temptation to try to use established law rather than to try to forge new ground. And so just because some freedoms got interpreted first, they tend to keep getting used in further litigation, in further attempts to take freedoms before the court, even though the others might also be very much applicable to a particular issue that arises and might even be more suitable in some cases. And then a third thing that's led to some freedoms being forgotten is that the courts themselves have tended to restrict the use of some of the freedoms insofar as they've said at times, and I think quite mistakenly, there's a paragraph in the Supreme Court of Canada's decision in Trinity Western where they say, well, once we've dealt with the freedom of expression argument, we don't have to look at association, even though those two protect different things. They sort of merged those in that, that paragraph and treated them as if they were the same, even though they weren't. Well, that's a phenomenon that occurs, that courts try to simplify their task at times or try to limit the number of freedoms that are being argued. And that sort of reinforces these prior reasons why some of these freedoms end up being forgotten. But there is a real problem in some of these freedoms being forgotten. There are important reasons why they're there, and there's a very lengthy record in the history, as I say, the international human rights law history that precedes the Charter on why these freedoms were there. If we lose attention to them, we lose attention to how Section 2 works as a whole. There are principles around legal interpretation of the importance of reading constitutional provisions holistically. I mean, to understand what expression means, it's actually important that it's there alongside freedom of thought, belief, and opinion, for example. And to understand what freedom, what the fundamental freedoms mean, it's important that we be looking at all of them. And when the jurisprudence simply hasn't developed on some of these freedoms, what if circumstances change from what I described? In 1982, there weren't a lot of prohibitions on gatherings. We probably never imagined the kind of prohibitions that we're seeing today. Now, there are strong arguments in terms of public health related justifications for some types of limits on gatherings, but because we don't even have much case law about freedom of assembly, it's much more challenging to say what the governments can or can't do. When does a restriction on assembly either become too intrusive, even in light of health reasons, or when does it stay in place too long as compared to those underlying reasons? Those are things the courts should be able to scrutinize. simply because of the importance of freedom. And in the lack of case law, it's much more challenging to do that. So the workshop that we held back in September, really one of the goals was to develop scholarship that could help the courts with the various forgotten freedoms. And I think that that the collection that's emerging from that is going to hopefully be very useful to the courts and others in engaging with them. But we're going to talk about the meaning of some of these freedoms here today, simply as part of the celebration of Charter Day.
Thanks so much, Dwight, and thanks for all of your work. And it is a true privilege for us at CLF to partner with the Forgotten Freedoms Project and the academic work that that it is doing and that you are leading. Professor Cameron, Brian, did you have any reflections further to Dwight's comments on you know, this nature of freedoms being forgotten and the danger associated with it?
Just a couple of very quick comments or observations, and not per se specific to the idea of forgotten, but I guess a couple of things about looking at Section 2 in its overall structure and composition. One of the things that I think we're lacking in the Charter jurisprudence is any sort of integral or holistic conception of fundamental freedoms, because the jurisprudence tends to look at the particular freedoms in their own right, and as we saw, the 2A and 2B are the leaders and the others are predominantly forgotten. So that's one thing. But the other thing is, and Dwight touched on this in mentioning TWU, the law school case, you know, another thing that sort of gets lost or forgotten or sidestepped too much, in my view, in the Charter jurisprudence is the problem of compound violations, where you have sections 2A, 2B, and C together, and the court chooses to fix on 2B or 2A and to sideline the other guarantees. And I think that really discounts the severity and aggravation of the breach when the court does that. And TWU is not the only example. Another one that has always bothered me a lot is R versus Kawaja. So I'll just stop with that intervention. Those are two things I thought might be helpful to add.
And just building on what Professor Cameron just said, I think that and actually building even on an earlier comment that she made in her opening remarks, is one of the things that gets forgotten apart from some of the fundamental freedoms is even just the concept of freedom itself. You know, what does freedom more generally mean? These are all freedoms of ... different things, but this concept of freedom itself is kind of nebulous. One of the only places I've seen it, again, I mentioned this decision earlier, is one of the first decision on a fundamental freedom, this case called Big M Drug Mart, in which the court does actually sort of speak about what is freedom more generally, what is a free society before, and that made sense. It was the first time it was kind of venturing into this landscape, but since then there really hasn't been very much talk about this unifying concept, which seems to be pretty important to understand that before we even get to the things that come after the word of. So I'll just throw that out there as well.
Great observations, everyone, and lots of room, I think, for the Charter to grow in all of these areas as it steps into its 39th year. So we're now going to talk about the specific freedoms and specifically the forgotten freedoms, what they mean, and obviously it's hard to do any of them justice in the 5-minute slots that we're kind of associating with each of them. Before we do, I've just launched our second poll, which is asking you, our audience, which of the forgotten freedoms in Section 2 are you most interested in learning more about? Now, received a good comment in response to our first poll, which is there should be an all of the above option, because it's hard to force you to pick your favorite freedom or the one that's most important, and obviously these are all important, and we're trying to avoid this notion of picking one above others. So, you know, message received, but for the purposes of our polling, we would be curious to know just where folks stand in terms of the topics that they're interested in, or areas where they just feel there hasn't been a lot of discussion and they're interested in learning more. So how this will move forward is we're going to have each of the panelists speak about one of these forgotten freedoms and just kind of give a very high level overview. Again, as we go through, if you have questions, please type them in the Q&A box, because we will be having a Q&A at the end of the presentation. And I'm just going to close the poll. So if you haven't yet voted, just take a minute now to vote. Brian Byrd is going to begin with a presentation on conscience. Brian just completed and successfully defended his doctoral dissertation on freedom of conscience. Congratulations to you on that, Brian. And so is very well positioned to speak to that freedom. Okay, I'm going to end this poll. Votes are still coming in, so I don't want to pull the plug just yet, but in the interest of moving forward, I'm going to end the poll and let's see where we landed. Okay, so thought, belief, and opinion is one of great interest, 46%. But all the other freedoms as well are ones that folks want to hear about, and I'm sure all of the above would have been a very popular option. So Brian, over to you on freedom of conscience.
Sure, thanks, Derek. And I should have said earlier, thank you so much to the Christian Legal Fellowship, to the Forgotten Freedoms Project for the opportunity to be here. It's a real pleasure. So yes, freedom of conscience is near and dear to my heart because I spent 4 years working on it for my PhD. And I went into my PhD at McGill University thinking I wanted to do something on freedom of religion. Section 2A protects freedom of conscience and religion. And I thought, yeah, let's do something on freedom of religion. And then I realized in my very early kind of, before I landed on my topic in a very kind of firm way, that freedom of conscience in that section of the Charter, 2A, has been all but forgotten. And so that got me thinking, here's an opportunity to, as one tries to do with a PhD, make a contribution to a gap in the field. So basically, my question in the PhD was to try to answer these three. What does freedom of conscience protect? Why do we bother putting it into the Charter? Why did it make the cut, so to speak? And then the third is, when can it be limited? Which is often kind of where the rubber really hits the road for any part of the Charter, is when can it be limited by the state? When is it reasonable to limit it? And so just to kind of give a very brief, before I go into those questions, and I'll keep this very broad brushstrokes, I'll just say that, really the only decision that I found in the Charter era that has dealt with freedom of conscience in isolation from freedom of religion, and that's kind of been freedom of conscience has been a casualty of being kind of subsumed into religion and not given independent kind of reflection and consideration by courts. The one case in which it got independent attention, it's always interesting to see what kind of cases make it into court decisions, was a decision concerning an inmate in a federal prison who originally requested vegetarian meals as his diet while in prison on the basis of his Hare Krishna religious faith. But while in prison, he renounced his faith and said that he wanted to continue receiving those vegetarian meals on the basis of a moral conviction, not tied to any religion, concerning vegetarianism. And what was surprising is that the Prison Corrections Canada had offered those meals in the first place when he was kind of housing it under his religious faith. But once it became a purely conscientious conviction, they refused to continue the meals. So enter the lawyers and litigation, and the judge in that case, it was a federal court decision from 2002, said that freedom of conscience does have independent content. And in this case, even though this individual is not religious anymore and not basing his moral conviction about vegetarianism on religion, by virtue of freedom of conscience standing alone and being in the Charter, he's entitled to those meals. So that's pretty much the only kind of very independent, and even in that case, it was a very short decision, only a few pages. So I thought, okay, there's work to be done here. And so in a nutshell, what I kind of argued in my PhD was that, well, what does freedom of conscience protect? My view in a nutshell is that it protects our freedom to live in alignment with our moral convictions. And the important point is, regardless of where those moral convictions come from. So regardless of whether you get to your moral judgments through religious formation or through other forms of formation, if it's a moral conviction, if we can get to that point, we're dealing in the currency of freedom of conscience. So whether you're maybe a Mennonite who kind of is pacifistic and doesn't want to go and bear arms and go to war, or whether you're a secular pacifist who doesn't want to go to war, both individuals share a bottom line moral conviction. They've got there through different kind of vehicles, one through religious formation and one through maybe just more kind of generic moral reasoning. But there's a shared moral conviction, and they may even have somewhat similar, not totally, but kind of moral views about war. So you can apply this to the healthcare context as well. If you're a doctor who doesn't want to be involved with medical assistance in dying, whether you're Christian, Jewish, agnostic, or atheist, if there's a moral conviction that you hold that says that this is just, I can't be involved with this, they all benefit from freedom of conscience. And so then one of the big questions, one of the big things I had to do was to try to distinguish the division of labor between conscience and religion in Section 2A. What do they both do if they have independent content? And again, the very kind of broad brushstrokes view that I take is that freedom of conscience deals with as moral convictions, and it's tied more intimately to action. When we think of conscience, we often think of, the angel and the devil and telling, do this, don't do this. And it's kind of intimately, popularly understood as being, what should I do or not do? So it's not so much with the internal form. I mean, you're thinking about these things, moral reasoning, but we usually think of conscience of tied to action and moral action. And then for religion, kind of on the other side of the ledger, again, putting in very broad brushstrokes, would be kind of faith-based practices and faith-based beliefs and practices. So that's a kind of very broad distinction between the two. They often kind of come close together and there's overlap, but there is, I think, the possibility to have a workable division of labor between the two kind of prongs of Section 2A. And then just very briefly, why it is that freedom of conscience makes the cut. Why do we bother putting it in there? Which is a good question to ask for all of the parts of the Charter. In a nutshell, I think there's an individual, all of our moral commitments, these things that we would say are, that form part of my or your moral code, they touch on kind of our identity and our integrity in a very fundamental way. They basically speak to who we are and what we stand for in a very fundamental sense. And so freedom of conscience allows us to kind of live our lives, to use a phrase that I found in a book by the author is escaping me at the moment, I'll try to remember. He said that, freedom of conscience allows us to kind of live our lives as kind of coherent narratives in that very fundamental way. So we can kind of look at ourselves in the mirror, so to speak. So that's kind of why, that's the individual kind of dimension of why freedom of conscience makes the cut. The other dimension, which was pointed out to me by one of my law professors from the University of Victoria, who is contributing a piece to this collection that's being prepared as a part of the Forgotten Freedoms Project, is that freedom of conscience also enables kind of democratic citizenship in terms of trying to dialogue and debate about what makes a good society, what makes a moral and ethical and good society. And without freedom of conscience, we can think of so many examples in history of people who have acted on their conscientious convictions and have transformed societies. A person who often comes to mind for me is someone like Martin Luther King, looking at the United States. I mean, he acted on his moral convictions, of course, informed through his religious faith, and his actions transformed a country and have had a huge impact on the world. And so there's both this individual value to freedom of conscience in terms of allowing me to, and all of us, to live our lives coherently from a moral perspective and to safeguard our integrity and identity. But then on the other side of it, freedom of conscience allows us to try to dialogue, to debate, to speak about these often very sensitive issues. If we're dealing with moral and ethical issues, they're bound to be sensitive and delicate. But we have the freedom to try to build this better society through having an openness for debate. And to use a phrase that Professor Cameron used earlier, there's this ability to be courageous and to speak openly from the perspective of trying to build a better society, which we're all interested in. I won't go into the just because of time, because it's a bit of a thorny issue of when conscience can be limited and when it can't be, but there might be some opportunity in the Q&A. So I'll leave it at that for now, and I thank you for indulging me.
Thanks so much, Brian. Very thoughtful overview of freedom of conscience. I want to invite Professor Cameron, Professor Newman, if they have any reflections on conscience.
I'll just again say something very simple, and it's really just a point of observation. I'm become a very, very big fan of Big M recently. And one of the things I have noticed in teaching Big M over the years is that Justice Dixon, in writing about Section 2A, he writes continuously about freedom of conscience and religion. And I've actually become a bit obsessed by this. I've gone through the decision and circled all the times he's used those terms inclusively. And I've always asked the students, I've said, is this just a tick on his part that he felt he had to repeat the text in every reference in his decision? Or do you think he means it to be inclusive? He means the reference in an inclusive way, and that he is really talking about conscience as well as religion. Well, I don't really have the answer to that, but the 2A jurisprudence didn't have a whole lot of development again until Amselem, which wasn't even a charter decision. And in Amslam, that's where we get a very clear focus or narrowing of Section 2A specifically and exclusively to religion. And I've always just found that very interesting. I've never been particularly convinced of the reasons why religion is so much privileged over conscience under Section 2A. So I'll leave it at that, Derek. Thank you.
And I guess I would just add that one of the interesting elements is going to be how 2A might develop in cases where religion isn't brought in or simply isn't pertinent, like the case that that Brian described on the individual who was asserting a conscientious belief in vegetarianism that ceased to be associated with religion. One of the challenges, of course, is that often conscience gets subsumed again into religion if the court has the chance to do that. And this Ontario doctor's case being the example where a conscience claim was put in the case, but then the court just merges it into religion. And there may need to be a lot more cases taken separately from, that are entirely separate from religious claims, that are conscience claims, in order to get the courts to interpret what freedom of conscience might mean, or just some way of stimulating the courts to develop that branch more, because they have had this tendency to subsume it into religion now when it's actually an independent freedom. So that'll be something interesting to see in the years ahead.
Yeah, thank you very much, Dwight and Jamie, for those comments. And I would just add as well that I think you know, a lot of what is lost when conscience is overlooked is this whole idea of the intense and good faith and reasonable moral reasoning and moral philosophy that a claimant is engaging in. I think when the focus is placed on freedom of religion, our jurisprudence focuses on religion as being a connection with a divine being and supernatural beliefs. And I think those beliefs can sometimes be easily dismissed by an opposing party or even by a decision maker as being, you know, outside of the realm of reasonable thought and reasonable engagement. And I think we see that in the doctor's case, where there's an assumption made that physicians who are unable to participate in euthanasia and abortion are doing so solely on you know, religious, dogmatic, doctrinal grounds, as opposed to, or to the mutual exclusion of decisions that are rooted in their ethics and their philosophical framework and their understanding of clinical practice and the best interests of their patient, which are all, you know, they fall within that category of moral reasoning. They're informed by their religion, but it is sort of this artificial bifurcation that's happened where explicitly or implicitly there's been this assumption that religious beliefs are in one category and philosophical, ethical, moral reasoning are in another category. And the focus has been entirely in the jurisprudence on religion, I think to the detriment of taking, you know, a really close, you know, thoughtful examination of why it is that a claimant believes what they do. And part of that is because courts have been very resistant to entangling themselves in religious doctrine, is the terminology that's often used, and rightly so. But I think that has come at a cost, because when the court refuses to even look at some of the reasoning that's involved in a claim and just accept it at face value, they lose the force of the moral reasoning that lies behind it, and really engaging with the good faith reasons and the thoughtful reasons that a claimant might have in having an objection to something. So I think that's something that's really important to pay due to. Okay, so on that note, let's move over to the next forgotten freedom, which we've kind of lumped together. I think they are independent: thought, belief, and opinion, protected in Section 2B. This was the most interesting topic for our participants, Dwight, so you've got a captive audience here. Over to you.
Yeah, so I'm tasked with actually all of 2B other than expression, which is an interesting challenge, because often 2B just gets called the freedom of expression clause, which just goes to illustrate how far it is that the other parts of it sometimes are at risk of being forgotten in some way or another. One part that isn't forgotten, of course, at least entirely, is press or other media of communication. It's not forgotten in the sense that the Canadian courts aren't inattentive to the significance of freedom of the press, but they've still treated it as simply part of freedom of expression. But they have gone on to recognize elements like the ability to gather news as part of the freedom, which wouldn't make sense if you were thinking just of freedom of expression. There's something more going on. At the same time, though, they haven't treated freedom of the press as an independent freedom. And one of our participants in the collection, Ben Oliphant, has written on this in a number of pieces over the years. And we now actually have a Supreme Court of Canada decision that came very close, a recent Supreme Court of Canada decision that came very close to saying freedom of the press needs to be treated as an independent freedom, although it was still split 5-4 on that point, and only 4 justices in the Vice Media case were ready to go in that direction. But what would be the significance of doing that? And the other 5 didn't reject it, I don't think, but they just aren't quite ready to go there yet. It would be very significant, though, I think, in terms of the recognition of some of the other elements of societal institutions that need to be protected for the press to be able to function with freedom of the press, and the full application of freedom of the press. The ability of those with press-like functions to act in ways that aren't subject to inappropriate restrictions on them, these sorts of things. So that's part of 2B. Another part of 2B concerns other media of communication, and no one writing that in 1982 was thinking about the internet, obviously, but 2B could have very significant implications for internet regulation that we haven't even started to think about in terms of the constitutional dimension there. There are a couple of scholars or practitioners who have, and we've tried to involve them in the project and this collection on the forgotten freedoms of Section 2 of the Charter. But there's a lot more to be thought about there, I think. And so again, a potential application to Section 2 of the Charter to something new in some really important ways. But the really challenging piece of 2B in some ways is this piece on thought, belief, and opinion. And I feel a bit pressured by the strong interest of people in learning about what this might mean, because I've been working on it a while and I still want to know what it means. But there are some ways of trying to figure that out. And one of the things that I've done in conjunction with some research assistants who've done a lot of good work on this is tracing back through what these terms meant in the instruments that influenced the Canadian Charter. Some of the instruments like the Universal Declaration of Human Rights, and the very significant discussion that went on in a cross-cultural context there before the adoption of the Universal Declaration. And these terms were discussed there. And then looking at what they mean in the text, and at also philosophical writing about some of this terminology. And there's some interesting philosophical writing, for example, on freedom of thought by a scholar named Lucas Swain, who's published on that. And thought, belief, and opinion are challenging freedoms to understand in a constitution in some ways, because they all seem to be inner freedoms in some respects. They're not about external actions in the way that expression is. Expression could follow upon thought, belief, and opinion. But thought, belief, and opinion in and of themselves are actually internal or inner freedoms in some respects. And so there was some discussion about that in the records of discussion on the Universal Declaration of Human Rights, or what get called in technical terms the travaux préparatoires of the Declaration. Well, what do these protect? I think in some ways they have to protect individuals against government coercion that affects their ability to freely think, to freely believe. And believe is a broader term than religious belief, which is the connotation it sometimes has. There was actually discussion around the idea that belief needs to encompass things like political belief as well. But any government coercion of the processes around thought, belief, or opinion would be something potentially causing concerns. Any undue government interrogation into individuals' thought, belief, and opinion also could raise issues that at least demand constitutional scrutiny. And undue, or well, punishment of particular thoughts, beliefs, or opinions could also raise issues concerning the constitutional freedom that's here. Obviously, there will be things that governments do that affect thought, belief, or opinion, and finding that balance of what's permitted within a free society is the challenging aspect here. And it falls in some ways to the Section 1 test. But realizing that those freedoms have some protection is significant. And maybe we don't think governments threaten them all that often, but there certainly are instances where they might have been the appropriate freedoms to use. For example, when there was discussion around the Canada Summer Jobs Program and government requirements around organizations affirming certain beliefs in order to qualify for government support for summer jobs for students. Maybe that's something that falls under these constitutionally protected freedoms and needs some analysis there, but we need a lot more content on what these freedoms are and what they protect. And so in the piece that I did last year on freedom of thought, and the piece I'm doing this year on freedom of belief and opinion, and some other pieces along with the research assistants and so on, we're trying to get at some of that, but there's a lot of work for us to do. And so we hope others will also engage with these freedoms as well.
Thanks so much, Dwight, for your work in this area. And obviously there is so much to be explored on the topics of the various protections in 2B. Professor Cameron, Brian, any reflections on 2B's protections?
Yes, I have 2 points, if I may. First, on freedom of the press and the media, just an observation on my part, and that is that I think one of the things that's missing in the jurisprudence, and the freedom of the press does get subsumed into freedom of expression, particularly on issues like the open court principle and so on. There's a very limited jurisprudence that is specific to the press itself. And I think one of the gaps in that jurisprudence is just an absence of appreciation on the part of the court of the key distinctive underlying rationales for a free press, which are democratic accountability and transparency. And it's not adequately understood, in my opinion, that the press, the independence of the press and the media has to be protected in the interest of self-governance of all of us, so that those vital values can be served. And no, I think you're right that there's been some endorsement or adoption of news gathering as a protected activity under Section 2B, but it really doesn't go very far, and the court is very hesitant and unwilling to open up the Pandora's box of freedom of the press. So now a comment about freedom of thought, belief, and opinion. And I was, I guess, well, I have one decision that has always bothered me a lot, and it's the Ontario Court of Appeal citizenship oath case that requires a mandatory oath to the Queen as a condition of eligibility for Canadian citizenship. And the court rejected the claim under Section 2B. And I guess this is just something to ask you, Dwight, which is whether the claim might have been better served or might have come across more strongly if the elements of thought and belief and opinion had been given some credence in the decision, because really when we look at expression, the court's definition and understanding of expression is very factual. It doesn't include these other elements which speak to a broader purpose and significance of freedom of expression. So I'm not sure I said that particularly well, but the other point I'm going to add, which I think is really forgotten in the jurisprudence, and it relates to this and summer jobs, and you mentioned, you sort of went at it a bit with your reference to government coercion, and this is freedom from compulsion, freedom from being compelled to affirm or endorse things that are phenomenally objectionable to the individual. And for some, the oath to the Queen is one of those, but there are any number of others. And I think, again, the court has been very reluctant to give too much room for freedom from different forms of compelled affirmation and so forth. I've been very unwilling to give room for those to grow in the jurisprudence. So I'll leave it at that, Derek. Thank you.
Derek, if I could just add a point, I don't know if Dwight wanted to respond, or if I can make a quick point. Dwight, I can let you respond.
Well, I'll just say quickly, I think the citizenship oath case is a really interesting case where attention to more of the freedoms would at least offer a richer analysis. And that's the kind of thing that's needed. And as you've said, freedom of expression is taken as a very factual sort of thing in a sense. The idea of expression as an activity intended to convey a meaning, and then with a protection against certain types of forced expression. It doesn't really get at the underlying issues of thought, belief, and opinion. And some have tried to think about the citizenship oath case in some slightly different ways. Leonid Sirota wrote an interesting piece on it, but it's not structured on thought, belief, and opinion. And they're, in some ways, maybe the most natural freedoms to have asked the court to think about. And then where it comes out, people could come to different viewpoints, but just the issues being raised, there could be rightly different ones raised than were the focus of attention.
I'll just make a very quick point. As Dwight was speaking, this is an issue that I found interesting, because I think that freedom of thought, opinion, and belief in Section 2B raised a bit of a question for me about the kind of conventional legal wisdom that's been with the Charter from pretty much day one, which is that there's no such thing as an absolute charter right. But all of the charter rights and freedoms, it's commonly said, and it's the conventional wisdom is that because of Section 1 of the Charter, which is that limiting standard, they're all non-absolute or can be limited. And yet, it's interesting that if thought, opinion, belief, maybe thought in particular, is primarily or maybe even exclusively about the internal forum, I wonder if there's some room for debate about whether that freedom might be, if not absolute, maybe quite close to, in terms of it's hard. I think we kind of get a bit nervous, particularly so when it comes to things like thought scanners, or I'm just being a bit facetious, but my point is that there might be some room for a debate about that principle of charter rights, all of them being non-absolute. It's interesting that Section 1 of the Charter, which sets out the standard that the state must meet to limit any charter right or freedom, doesn't actually say in advance that there will be such limits for all of them. It doesn't foreclose, at least the text doesn't foreclose a possibility of certain right or freedom being found to be immune, so to speak, from any of such limitations, that there would be no such reasonable or justifiable limitation of freedom of X that conforms to a free and democratic society. And interestingly, last point I'll say is that one of the early drafts of the Charter, if I can call it that, is a document called, I think it's called a Canadian Charter of Human Rights. It was written in 1968 by then Minister of Justice, Pierre Trudeau. And in that draft, the Charter, if I can call it that, he makes a comment to this effect. He uses the words belief and conscience, but he specifically is talking about the internal forum. Any freedoms concerning the internal forum, he says they may well be unqualified or absolute. So it's a bit of a provocative thing to throw out there, but I think that this prong of Section 2B, thought, opinion, and belief, raises that for discussion at least.
If I can just add on that, I think Brian's identifying a really interesting point about these inner freedoms. And in the discussions around the Universal Declaration of Human Rights, there was a lot of discussion back and forth between delegates like the French delegate René Cassin and the Lebanese delegate Charles Malak, where they were actually talking about the idea that these inner freedoms might be absolute. Now, as Brian says, we get very nervous about thinking that there are rights that could be absolute. But there might be at least some core of these inner freedoms that is absolute, and that wouldn't say that there aren't things governments do that affect some of these, but there might be some core element that in a free and democratic society we can't really abide by certain kinds of really intrusive acts against thought and belief and inner opinion. But it's a complicated question, but a really interesting one that is there present in some of the discussion.
Yeah, thanks so much. And I would just add, my comments on 2B are really tied to my paper that I'm contributing to this collection, which is the importance of all of the freedoms to this idea of truth seeking. And so one of the arguments I'm putting forward in my contribution to the book is that the pursuit of truth is a golden thread that links all of the fundamental freedoms protected in Section 2. Not that that's the only thing that these freedoms protect, but it's certainly all of them are geared towards ensuring that citizens are free to debate, to dialogue, and to push one another towards a better understanding of truth. And that's particularly so in the context of 2B. The Supreme Court has consistently held that freedom of expression, that is one of its core purposes, the pursuit of truth. And but I think we see that particularly with things like thought, belief, opinion, that no one has a monopoly on truth. No one can dictate or proclaim to citizens what they have to believe, what they have to accept as truth. And that's where the freedom from compulsion is so important. And with COVID-19, it's interesting to see how this is actually being brought into focus. In recent media reports, there have been some reports that the government is exploring this idea of somewhat of a false news type legislation that would punish individuals for publishing information on social media that is considered misinformation about COVID-19. And of course, that is well-intentioned. It's designed to protect the public from information that might be harmful about the pandemic. But it does raise a very deep philosophical question about who is determining what is and is not misinformation on questions that, are still largely being explored, where we're still not entirely sure of all of the impacts and effects, and even the government itself has shifted in its posture towards certain protections and how much they might be needed. And the idea that the government can regulate what we say on social media about what we think or our opinions about things like, this pandemic, it really raises concerns. Leonid Sirota is a professor in New Zealand, has a blog called Double Aspect, and a really thoughtful article yesterday that this is essentially positioning the government as the minister of truth, the ministry of truth, and that it's never appropriate for the government to dictate what is and is not, appropriate. That's where we do get into things like hate speech, and there are appropriate regulations that are imposed in some contexts, but they really have to be very stringently justified. And that's really important in this context. The last thing I'll say about thought, belief, and opinion is that it's interesting that those are separate from religion and from conscience. So these are separate things that are protected. They are distinct. They are discreetly set out. And as others have mentioned earlier, statutory interpretation tells us that that is intentional, that we have to take that seriously, that these are not superfluous words. And so I think that means that there is something that's protected here that maybe religion and conscience do not protect. But I think it also informs our interpretation of religion and conscience, that religion and conscience are not limited to beliefs or inner thoughts. And some do want to interpret freedom of religion and conscience that way. We hear that argument a lot. You're free to believe what you want. You're not free to act on those beliefs. And I think what is clear in the jurisprudence, which is that freedom protects the manifestation of religion, is also borne out in this language that's used to suggest that there is more in Section 2A than just the protection of thoughts and beliefs. So those are just some reflections there. I don't know if anyone wants to comment on that, but just maybe in the interest of time, we'll move forward to the next freedom, which is peaceful assembly. And we've invited Professor Cameron to lead our discussion on 2C.
Okay, thank you, Derek. This is 2C, the freedom of peaceful assembly, which until today was the most invisible and the most totally forgotten of Section 2's fundamental freedoms. And according to the opening poll, the entry poll at this session, it was only most important to 3% of those who responded. But in the second poll, asking what those participating would like to learn more about, it shot up to 11%. At least those are my notes. So anyway, 2C of the Charter, most invisible, most totally forgotten. So I'm just going to begin by asking the question, well, is that really so bad? How much of a problem is that after all? Because the easy answer is that freedom of assembly can be and has been dealt with under the auspices of Section 2B and freedom of expression. So one way of looking at it is to say, well, that's simple, isn't it? It's efficient. And when you deal with freedom of assembly issues under Section 2B, it works and it generates consistent standards in the jurisprudence across issues. And you can say that's generally a good thing. I'm going to give you 3 reasons why that is not a good enough explanation of why Section 2C is invisible and forgotten. First of all, and we've heard a lot of this already this afternoon in relation to the forgotten language of Section 2A and Section 2B. Section 2C is in the Charter for a reason. And the way I would put it is that Section 2C has full textual pedigree. It has Charter pedigree. And that's a very good reason why we need to pay attention to Section 2C and not ignore it, not forget it, not allow it to be invisible. A second reason is that I think freedom of peaceful assembly, and perhaps particularly now, really needs to be hardwired into our political and social conscience. It's not just one of the elements of Section 2, it's a basic principle of democratic and social governance. Assembly is a concept of cultural, social, political, religious value. It's got a high degree of symbolic and ideological importance. And if you would be able to trace this, the lineage of this from a long way back through to the pipeline protests of just a couple of months ago, through to what we may be going through as a society in the days ahead as we continue to struggle with the restrictions on gatherings and movement and the other kinds of restrictions that have been brought with the pandemic. And so I guess I would say that especially now when governments, including municipal governments, are quick to place limits on various forms of assembly, whether they're small, medium, or large, there is really a time and a place and an opportunity for Section 2C to be brought into visibility. And I stress again that, my comments are not really directed at, let's let Section 2C play a role under the Charter. I think it's more important than that. It's really part of the fabric of democratic governance, this freedom of assembly. And so that's a second reason. My third reason, I guess, has to do with the law and legal principle. So, I don't know about others, but I certainly don't make any assumption that what works for Section 2B is going to work for Section 2C. In other words, I don't assume that the standards that have been developed for freedom of expression are a fit for what protections are required for freedom of peaceful assembly under Section 2C. I've actually always been of the view that general tests and general standards are not really the best way to protect constitutional rights. If you really want to be serious about protecting constitutional rights, in my opinion anyway, what you need is a customized, issue-specific, bright line test that sets a high threshold of justification on limits. And if you want to raise the profile of Section 2C, if you want to be serious about freedom of peaceful assembly, it's not going to happen by simply applying Section 2B standards to the requirements of Section 2C. And I guess I'll stop by saying that, you know, now is kind of an interesting opportunity for Section 2C. It can come into its own in the days, weeks, months ahead. And it's an interesting opportunity for courts to rethink some of the assumptions that are embedded in the Section 2 jurisprudence. It's sort of, if you really want to put it out there, you could even regard it as an opportunity for a kind of a do-over of some of the basic assumptions and principles about how we protect freedom under the charter, because Section 2C is a charter virgin, and it's open to interpretation by courts. And so that's that puts out a challenge to the academics and scholars to make the proposals that can be acted on. It puts out a challenge to those whose freedom of peaceful assembly has been limited to raise that claim and not roll it into Section 2B. And then it puts a bit of a challenge on the courts to respond to that. So I think Section 2C it may have some interesting times ahead, and I'll leave it at that, Derek.
Thanks very much, Professor Cameron. Professor Newman, Brian, reflections on peaceful assembly.
Well, just wanted to maybe kind of just make a point in furtherance of what Professor Cameron said about the kind of high standard for justification. I think it's notable that 2C is the only fundamental freedom that has a kind of an internal qualifying word, peaceful assembly. And I'm wondering whether that may actually further your case of, it's hard to imagine if it's a peaceful assembly, maybe that as opposed to just an assembly, if it's peaceful, why would we limit it? Or it seems like it'd have to be a pretty high bar to limit a peaceful assembly versus an assembly. So just to kind of take the ball and run with it a bit further, that might be something that is worth thinking about. And I think that you're right that this is really a moment for us to take stock of and maybe have a reset the clock on paying attention to peaceful assembly, because I think given how invisible it is among the forgotten freedoms, maybe taking the cake on that front, maybe policymakers, decision makers in this moment might be even forgiven. If I can put it that way, to kind of had to kind of brush the dust off of 2C and realize, oh, that's there. And maybe that is, to a certain extent, evidence of a certain hardwiring, to use your words, it's already in a robust liberal democracy like Canada, but it doesn't excuse us not paying attention to it. So just those 2 points. I think you hit the nail on the head.
And I guess I would just add that I think one of the questions to tackle is to what degree we're going to insist that assemblies need to be for particular purposes, or to what degree we're allowed to have assembly for a variety or even a broad or even an unrestricted range of purposes. And I think the current circumstances actually highlight that, because we might have thought in the past about governments limiting assemblies that were for particular kinds of purposes, political protests, and then think, well, freedom of assembly, we're wrestling with the question of, well, when can governments interfere with those purposes and not? And it almost invites 2C to just be tied to the other freedoms. But now we're actually thinking about just overall prohibitions on gatherings of more than 50 or more than 10 or more than 2 people, depending on the circumstances. And so when those kinds of restrictions can be justified or not raises not just the justification questions, but actually the question of what we're ready to defend through freedom of assembly, and the idea that maybe the purposes don't need to be as restricted as we might have thought in the past freedom of assembly might have been about.
That's great.
Thanks so much. I think what I would add too is, as Professor Cameron noted, what our current circumstances have brought into focus, I think, is how much we take physical gathering for granted. And that is now something that we're really experiencing, and it does really highlight the need for 2C. And just building on Professor Cameron's note about this being an opportunity, I think thus far the literature on 2C has focused on the value of assembly because of its expressive content, the need for a group to gather together in a protest because you can amplify your voices collectively that you cannot necessarily do individually. And I think there's a lot of value in that. But I think assembly also protects something more than just expressive content, that there is something inherently important about being able to gather physically with other people. And that might tie in more to a notion of self-fulfillment or self-expression, or just, you know, the importance to the individual of being able to be with others, and just that social interaction and cohesion that we experience. I mean, even now with this Zoom webinar, it's wonderful that we're able to communicate remotely and via our webcams and computers, but there's no substitute for being in a room together, is there? And so I think there's something inherent in that that is protected, that might bear fruit in some of the future jurisprudence and literature. And our workshop had some great discussions. We had Professor Basil Alexander from UNB, Chris Kinsinger and Mayaka Eziana from the University of Saskatchewan, and we're really looking forward to their contributions to our forthcoming collection. Okay, in the interest of time, I'm just going to move forward now to the final forgotten freedom, which is freedom of association. And again, some might be surprised at the notion that this is forgotten because there is so much jurisprudence on 2D, but of course it has been almost exclusively in the labor context. So almost all of the cases, virtually all of them in fact, have looked at association in the context of protecting unions, labor rights, right to collective bargaining, and that is important. That is an important aspect of freedom of association, but it is really only part of what association protects. And if you look back at some of the earliest pronouncements of association and why it's protected in the Charter, certainly more was contemplated than just collective bargaining and labor law. And in fact, one of the earliest pronouncements came from Chief Justice Dixon, who was dissenting at the time in the Alberta reference. But interestingly, that dissent has now become sort of the leading passage on what association protects. And I think that in and of itself is an interesting emphasis on the value of dissent. But what Justice Dixon talked about was that association protects the profoundly social nature of human endeavors. That kind of ties into what we were just talking about with the social nature of physical gatherings, but also to protect the individual from state-enforced isolation in the pursuit of his or her ends. And Justice Dixon talked about the need for individuals who on their own might be vulnerable and ineffective, needing to have the freedom to gather together with like-minded individuals in pursuit of a common goal in order to put them on more equal standing with a coercive power. Now, largely that has been limited, of course, to you know, the employment context. The employer is seen as that you know, Goliath, and we need to protect the David in that situation, which is the individual employee, by allowing them to gather with other employees to form labor unions. But really, Justice Dixon wasn't just talking about the employee-employer relationship. In fact, he specifically said that freedom of association is designed to protect individuals in vis-a-vis their relationship with the government in all spheres of life. And so what I think is really important is that we focus on that aspect, that association is something that is valuable in civil society, whether it be religious association. Again, that has been really subsumed into freedom of religion. But as Professor Cameron said, the test for freedom of religion, 2A, may not necessarily be applicable in the context of religious association under 2D. And I think some of the case law has borne that out, where the 2A test, which talks about, you know, the need for there to be a nexus with your relationship with the divine. Even more recently in Trinity Western, the focus on the mandatory nature of a religious belief. Well, that doesn't necessarily translate in the context of religious association, where you could argue, well, nothing in your religious belief forces you to be in an association with other people. But that misses the point entirely, that an association is a voluntary collective, which is a good in and of itself, and allowing individuals to pursue a common goal, but also is acting as a vanguard to state power. And that was recognized most recently by the Supreme Court in a case called Mounted Police Association, where they said that the emergence of association as a fundamental freedom is one which permits the growth of a sphere of civil society free from state interference. And the court went on to say that has its roots in the protection of religious minority groups. And that's good not just for religious minorities, but also cultural minority associations, racial minority associations, philanthropic and charitable associations. These are all important groups that contribute to civic society, but also act as something of a check on state power that ensures that there isn't just this monopoly, that there are groups that are able to speak back to coercive action. And Andre Schutten from ARPA has done some great research on this and is contributing a chapter on this very topic to our upcoming collection. But I think it's important that we look at this as a freedom that is good, not just for the individual in terms of allowing them to flourish in associating with others, but also in preserving civil society, that is a society that is cohesive, that is democratic, that is free, and that is not completely coerced under government power. So welcome thoughts from the three co-panelists on association before we turn to some excellent questions that have been coming in.
I think that time is probably running a little short. I will just say that in the Section 2D jurisprudence, there have been lost opportunities to take the guarantee outside the labor context. And starting with the Law Society of Alberta decision back in, I think it was 1989, and all the way through to Kawaja and TWU and Suresh. That's a first point. A second point is that I think that the labor context really messed up the court's conception of non-association or freedom from association, because I mean, I think it's just instinctive that the charter ought to protect an individual from being compelled to associate herself with an objectionable state-prescribed message. But that became a very difficult proposition because of the enmeshing with the labor issue. I'll leave it at that. Thanks, Derek.
And time is certainly getting very short, but I'll just say it's been a section with a very tortured history in some ways. I mean, if we look back to the very earliest cases where the justices seem to have thought that their best description of freedom of association was a golf club. And then that was rightly critiqued by all the labor people over the years. Then in the course of focusing on the labor context, they forget about something like a golf club or any of the richer kinds of associations that could also exist alongside labor-related associations. And so it's, I mean, 2C is one with sort of no jurisprudence or almost no jurisprudence. 2D has a lot of jurisprudence, but it's a very confused jurisprudence relative to something that would get at the full potential of 2D. And so there's some real opportunities in the time ahead for the courts as well.
And Derek, just very quickly, I'll just say that I think you kind of touched on this in your comments, is that I think one of the biggest risks of viewing freedom of association as exclusively or primarily restricted to the labor and union kind of dimension is that it risks, and just in our own kind of consciousness, our own kind of awareness of devaluing just the wide range of the contributions of the wide range of associations within civic society, philanthropic, cultural, charitable, religious, etc., and the work that they do to basically enriching our democracy. And so I that's one of the big concerns for me, is the message it might send. And then when the time comes for maybe the test of maybe expanding it to those organizations, will that kind of maybe that residue that we've built up perhaps coming back to haunt us?
Thanks so much, everyone. Some real grist for the mill here and so much more to unpack. And unfortunately, we are running out of time. I'm going to launch our next poll before we move into the questions, and that is, which of the freedoms are you most concerned about in terms of being at risk? So feel free now, everyone, go ahead and answer that poll. You answer that question while we answer yours, and I'm just going to dive right into these. Some great questions here in the Q&A box. One question that has come out, and this is something that we've been thinking through as well, is, we're talking about all these independent freedoms. Gerard asks, though, that, what is to be made of the fact that these are set out in 4 paragraphs instead of 9? Conscience has been paired with religion. Thought, belief, opinion has been paired with expression. Does that not suggest that there is a commonality of purpose in the multiple rights contained in Section 2A and 2B, for example? So, why is it that we are suggesting that these are standalone rights if they're being grouped together? Is that contrary to principles of statutory interpretation? Isn't there a commonality, or, what is the basis for distinguishing religion and conscience? A great question from Gerard, and welcome folks to answer that.
Well, I think it's a very good question. I think there's no question in my mind that you can see commonalities between the various prongs of the various sections, conscience and religion, which is more kind of at home for me. I think it's from a decision from Edward Books in 1986, 85, forgive my timing, in which the court said that, kind of linking the two together, spoke about how these two matters, conscience and religion, kind of, to really boil it down, enable people to kind of pursue truth in relation to the big questions in life. So you can see, for example, that you can draw, thought is an interesting one, because as I was chatting with Derek a few days ago, thought at one point was in the drafting period with conscience and religion, and it was dropped down to 2B. So the decision making as to why they ended up in certain parts, I think you can see certain commonalities. I don't think it takes away from the independent content that should be, is just as a matter of statutory interpretation, afforded to each of those prongs. The fact that they're together, I think, is perhaps thematic. They speak to related interests, but I don't think it takes away from their force or the obligation on our part to interpret them and give them independent content. Just a quick thought.
Okay, thank you, Brian. I think just in the interest of time, we'll just keep moving through these and kind of do these as rapid fire. There's a question about the test for Section 2A, which currently requires, there being a nexus with religion. Would anyone recommend dropping the nexus with religion for the purposes of freedom of conscience and just say all that you need to show is that this is a sincerely held belief, and then move to Section 1? Or should there be a separate test that's applied for freedom of conscience?
Professor Cameron, you mentioned Amslam earlier. I don't know if you wanted to talk about that based on... Well, I'm happy to try as well.
Yeah, why don't you try? I mean, I was just thinking it through and thinking I think it needs to be more than just a nexus with something, but I'm not sure what.
Yeah. I mean, I think at some point there will be, I think, a case where the court is dealing with someone who can't rely on religion because they're not religious, but they have a kind of fundamental moral, ethical belief, maybe in the healthcare context, in which the court will have to grapple with conscience. And it seems like part of that exercise will be perhaps doing what it did in Amslam, is saying, well, what falls within the ambit of conscience? Mm-hmm. I wouldn't be surprised if the tests for conscience and religion, when there is one for conscience, will have some similar features. Perhaps the court will also go in the subjective direction with conscience as well. But I guess it's kind of, we're waiting for that case. But I think there needs to be kind of a robust definition as much as is possible. I mean, the court gave a very broad definition of religion in respect of in Amslam, but it will probably do the same thing, I would imagine, with conscience. Just some very preliminary thoughts.
Okay, thank you, Brian. There's a question here about the Wall case and whether that was a freedom of association case outside of labor. So that case dealt with the autonomy of a church to make its own decisions about membership. And ultimately, freedom of association arguments were raised in that case, religious association, but the court declined to decide the case on charter grounds and instead decided it on the basis of justiciability and basically its jurisdiction to decide the case. So the charter was, although it was argued, was not directly invoked in the Wall case. There's a question here about, and Professor Cameron and others, but this is directed to Professor Cameron. You mentioned earlier that Section 2 requires that we respect each other's freedoms and differences. Building on this, is there a need for the state to occasionally support the exercise of fundamental freedoms against threats posed by non-state actors? For example, could freedom of expression or freedom of peaceful assembly also include some protection against the heckler's veto? And I'll give you a minute to reflect on that. I'm just going to show the poll here, and it looks like the largest concern is again about 2B, thought, belief, and opinion. 45% of you are concerned about the risks posed to Section 2B, but there are votes for the other categories as well. So interesting responses from all of you. Okay, and apologies to the panelists for having to answer these really deep questions in such rapid fire format, but Professor Cameron, over to you.
I think that in those kinds of situations, there's a choice to be made about whether you protect the speaker or whether you protect resistance from the listeners. And I think I would say that in general, the speaker's prerogative ought to be protected up to the point at which the speaker's activity crosses the threshold of harm. And then on the other side, I would say pretty much the same thing, that the heckler has a right to resist and protest, but not to the point of placing an effective veto on the speaker. And it's a very difficult situation to negotiate. You see these kinds of situations on university campuses. You saw them also, I think, in some of the public library controversies. And it's a very difficult question because there are rights on both sides. So I'm not able to give a very good answer at this point, but I would say that the best answer is to try and accommodate both and then look at whose activity crosses the threshold of harm and warrants being limited.
Thank you, Professor Cameron. Another question, in fact, a couple of you have asked about this. You know, what, for the purposes of freedom of conscience, counts as a moral conviction? So what is the definition of a moral conviction, and you know, how do we distinguish it from a mere preference? Again, maybe going back to that question about what is the test for what's protected by freedom of conscience. Brian, do you want to take lead on this one?
Sure, that's my next PhD. What counts as a moral conviction? No, I'm just kidding. But that is a big question, so it's a good one. I mean, I think that it's fair to say that we often have a pretty instinctive sense of when morality and ethics are involved. You know, whenever harm, kind of just whenever rights are involved, whenever fundamental interests are involved, life and death situations, injury. I think oftentimes what counts as a moral issue, a moral conviction, is intuitive. It doesn't take. There's probably a lot of common ground, and people are often quite in agreement on that front. But a full answer to what counts as moral reasoning and a moral conviction, it's tough to answer, especially in 30 seconds. But that is another PhD question. But it is the substance of what, you know, if we're going to have a test for freedom of conscience, and the test, as I put it out, is, you know, the freedom to live in alignment with your moral convictions. The court is going to have to, perhaps, in addition to dealing with what counts as conscience, it's really the question is what counts as a moral conviction. So the short answer is, I think it's often instinctive. We don't have too many debates of whether this person is actually raising a moral conviction, but that seems to be maybe one of the reasons why people are a bit worried about freedom of conscience. Is it going to be that it'll open a Pandora's box and you'll have people saying that their conscience requires them to do a whole bunch of things that we can't envision at this moment. But I think in terms of what the core is of kind of moral issues, moral reasoning, there wouldn't be too much controversy. But maybe I welcome other views.
Thank you, Brian. Maybe this is a question for Dwight. Is there a potential case to be made with respect to freedom of the press that as government is increasingly funding and setting criteria and perhaps regulating news media, is this a potential infringement of freedom of the press? Similarly, what about publicly funded news media organizations? Does that raise concerns about the independence of the press for the purposes of 2B?
I think these are the kinds of questions that we could answer better with a more developed freedom of the press jurisprudence. I think government regulation or government funding conditioned in certain ways probably could raise some issues about the institutional independence of the media. I don't think the mere fact that government funds a public broadcaster is likely to raise a freedom of the press issue, but I think other kinds of government intrusions in the independence of media institutions could raise some interesting questions, but we would need a lot more on the jurisprudence in terms of what institutionally is needed for a free press and in what ways can government actions end up interfering in that.
Thanks, Dwight. A couple of quick questions I can address quickly. There's a question about good academic literature on Section 2C. Professor Basil Alexander has been a leading academic in this area from University of New Brunswick. He has a couple of papers on his SSRN page that are really thoughtful. And of course, our forthcoming collection will have a couple of papers as well from Christopher Kinsinger and Namayaka Aziana. Someone also asked about the Justice Dixon quote I mentioned. That is from the Alberta reference in his dissent. Okay, there's some questions as well here about the meaning of the word fundamental. So we talked about how the word freedom hasn't really been given a lot of thought as an independent word in statutory interpretation. Anyone have any reflections on what kind of work is being done by the adjective fundamental? And does that change the Section 1 analysis at all in terms of determining whether something is justifiably demonstrated as a limitation?
I mentioned earlier on this point about with freedom of thought, for example, with the possibility of maybe there being even an absolute charter right to freedom of thought, for example. That, of course, then brings into the question this idea of a hierarchy of rights, which is the Supreme Court of Canada has said many times there's no hierarchy of charter rights. And yet, to this person who's asking this question, it's interesting that, with a qualifier like fundamental, does that kind of bump up a bit against that idea of the hierarchy of rights? And even thinking of outside of Section 2, when you think of rights such as Section 7, life protected, I think we can all agree, just as a matter of common sense, that without being alive, we can't enjoy really any of the things in the Charter. So I think there's a lot of work that needs to be done on kind of nuancing perhaps this idea of whether certain rights are more fundamental than others. Even in the seminal Section 1 case, Oakes from 1986, if my memory serves me, I don't want to misquote it, the court says something along the lines, it may not be Oakes, but it's another case around that time, that basically the Charter is an expression, an articulation of many values and principles, some of which are more fundamental to a free and democratic society. So tying it into that portion of Section 1. So I think that this question is a good one. I think there's more work that needs to be done on what that word fundamental means and kind of the overall understanding of the Charter. But I think Professor Cameron, you probably had some thoughts.
If I just could add quickly, it's interesting that I don't know that we paid really that much attention to the descriptor that these are fundamental freedoms. And it's interesting that when there's a violation of principles of fundamental justice, they can't be saved, the violation can't be saved under Section 1. And accepting that Section 7 is constructed a completely different way, I think it's a good observation that we may not have paid sufficient attention to the significance of calling these our fundamental freedoms, because they could quite as easily be our freedoms, but there are fundamental freedoms.
And I'll just to clarify what I said earlier, that case I mentioned is from 1987. The case is called Lyons, Lyons. The court, it's a year after the Oakes decision, which basically gave us the test that we still have for Section 1. And in Lyons, the court said that the Charter protects a complex of interacting values, each more or less fundamental to the free and democratic society that is Canada, and citing Oakes for that. So there's a lot of discussion that can go on.
There certainly is, and these questions are still coming in. So obviously there's a lot of interest in these issues, and I do have to apologize that we're not going to get to all of them, and we were already over time. I think maybe just one last question here for the group. There's a reference to the Supreme Court's decision in Trinity Western, and the dissent talked about a concern that the charter might become or act more like a sword rather than a shield due to the approach that the majority adopted. Have we witnessed this directly or indirectly happening in Canada? And any reflections on, that idea of the charter being intended to be a shield rather than a sword?
It depends very much what the metaphor means, I think. It means certain things in that dissent. But in talking about it more generally, we could mean different things by that metaphor. So I think it's actually very challenging to engage with that kind of a metaphor and be precise in what we're saying. Is that something about positive versus negative rights? Is that something about the ways in which the charter is used to attack government actions but not to protect them? I mean, there are a lot of different ways that could be used. So I'm personally reluctant to answer something couched in such a complicated metaphor, not taking anything away from the person who asked it. It's just I'm not sure what they're meaning by it.
Yeah, no, fair point, Dwight. I think, I'll just add that, at least in the context of our discussion about the fundamental freedoms, obviously a number of Section 2 freedoms were invoked in the Trinity case. And, a criticism that the dissent had and that others have had since the decision was released is that those freedoms really weren't given their proper due, in part because the court invoked this idea of charter values to effectively outweigh the protection of those freedoms without recognizing that those freedoms themselves are also charter values. And so the court kind of pitted this abstract notion of the charter value of equality, which was not directly raised in that case. There was no claimant invoking Section 15. Rather, the court looked at this general idea of wanting to promote equality in the abstract as effectively trumping these fundamental freedoms. And it was almost a pitting of the charter against itself, instead of recognizing that the charter itself has already done the work of recognizing that these freedoms have to coexist. And I think the dissent did a better job of fleshing that out. Obviously, that is probably a webinar in and of itself, but it is, a fair question. So let's unfortunately park it there. Last question for the group, just kind of a very quick reflection. As the charter looks to its next 38 years, what are you most hopeful for? And what are you most concerned about as it pertains to Section 2?
I think I'll just say very quickly, I really hope that these, and perhaps it's an obvious answer, that these forgotten freedoms become less forgotten through initiatives like this, and that by doing that, by becoming more aware of these freedoms, I think I like what Professor Cameron said earlier about them becoming more hardwired, that we will see just a more general respect for the charter by default, and by doing that, we only stand to benefit. So that's kind of my hope. My concern that they will remain forgotten.
I would say that. Go ahead.
Go ahead.
My hope in some ways would be that we move towards modes of interpretation that ensure that we don't have forgotten freedoms, but that offer very consistent modes of interpretation of the Charter in accordance with the rule of law, but that includes then these forgotten freedoms. My concern would be that we don't see that kind of move, and we continue to see some of the kinds of challenging, sometimes inconsistencies that we've seen over the years. But I think we can hope for better.
My hope is, more of a broad brush kind of a hope, and my hope is that we see over the years more of a buy-in for freedom in this country. both in public discourse and in the jurisprudence as well, and a deepening of respect for difference. And I don't mean the kind of shrill and virulent freedom that we see in the US, like we saw on the US news last night, but I mean more kind of a we the North commitment to freedom that values difference and gives it the voice and space it really requires. And I guess the second thing I'd like to see is a real deepening of the scholarship and work on theories of Section 2 constitutionalism. I don't think the academic community, myself included, has done enough on that front up to now.
Yeah, thanks so much, everyone. And I would just add, very much in a similar vein that, I think my hope is what is laid out in that last paragraph of the British Columbia Court of Appeals decision in Trinity Western, that I think sets out a roadmap of what a free and democratic society is, one that admits of and accommodates differences, that allows its citizens to be free to think, to disagree, to debate, to challenge the accepted view without reprisal. And I think Section 2 gives us all the tools we need to achieve that, but we need to take them seriously and give them all their proper due. So with that, I think we're going to wrap up. We've gone about 15 minutes over time, and thanks to all of you who have stuck around to the end. So sorry to those that we weren't able to get to your questions on, but we have saved them, and this might be something that if we do a future webinar, we can focus on some of these questions. Just launching our final poll. Moving forward about fundamental freedoms, what are you interested in learning about? So our Forgotten Freedoms discussion today has been focused on Section 2. Are there other freedoms, and there are a lot of other freedoms that have been forgotten outside of Section 2 that might be of interest? So for fundamental freedoms as they were understood and interpreted before the Charter, other freedoms that exist in Canada, and in fact the Charter has a provision that says that nothing in the Charter takes away from other freedoms that exist in Canada. So it already contemplates freedoms outside of Section 2. Freedoms recognized in international law, and just as one additional example, artistic or musical freedom. So we welcome your views on that. Again, we really want to thank our co-sponsors today, the Christian Legal Fellowship and the Forgotten Freedoms Project. And also want to acknowledge as well that this research that we've been discussing today and have been talking about was associated with our Forgotten Freedoms workshop hosted in 2019, which was funded in part by a grant from the Social Sciences and Humanities Research Council. So thank you to SSHRC for their support. And again, if you have any questions that we didn't get to, please do feel free to put that in the chat box. And again, also want to encourage you to check out our video that we've produced in conjunction with the Forgotten Freedoms Project, which is available on our website and on YouTube. So thank you all so much for taking part in this discussion. Again, want to thank our panelists, Professor Cameron, Professor Newman, Dr. Brian Byrd. A real privilege to present this with you, and maybe we'll get the band back together for a sequel webinar to talk about all the questions that we didn't get to. So with that, we can sign off. But before I do, let's show the results from the poll. Okay, so a lot of you are interested in learning about the fundamental freedoms as they were understood and interpreted before the Charter, but certainly interested in the other topics as well. Well, thanks again, everyone. Happy Charter Day. Have a wonderful day and a wonderful weekend. Thanks for being with us. Bye for now.